Hello, my name is Jennifer Popchak Hakim, and I'm from the Office of Mental Health Services.
And I'm Maureen Bailey. I work for the Healthcare Authority. I am the Enhanced Peer Services Program Administrator. And welcome back to Module 8. This is part of the intersection of behavioral health and the law series. So again, Module 8, Civil Commitment and NGRI. So please grab your manuals that were sent to you or emailed to you, and you can follow along with us. So what will you learn in this module? So we'll go over an overview of what civil commitment is. And we'll go over some definitions of what a felony conversion is, also known as a felony flip. We'll go over what is not guilty by the reason of insanity and that process. We'll look at what the Ross settlement is and the function of a public safety review panel. So first off, what is civil commitment? So civil commitment is a determination by a court that a person should be detained for. So evaluation, treatment, or both. And this could take place in an inpatient setting or a less restrictive setting as well. So what are some of the requirements? So there has to be a presence of a mental disorder. So and then there's some other criteria that are frequently included in that. So dangerous behavior to self or others, gravely disabled, and the need for treatment.
All right, so I just got a couple of pieces to throw in there. So gravely disabled means a condition in which a person, as a result of a mental disorder or as a result of the use of alcohol or other psychoactive chemicals, is in danger of serious physical harm resulting from a failure to provide for his or her essential human needs of health or safety, and manifests severe deterioration in routine functioning evidenced by repeated and escalating loss of cognitive or volitional control over his or her actions and is not receiving such care as is essential for his or her health or safety. Kind of a big, huge definition, but we throw those things out there, and sometimes it's kind of nice to stop for a second and define it.
Yes, most definitely. Thank you for that. Sure. And so we talked earlier, I think it was in Module 2, about the role of a designated crisis responder. And so they have a role in this process as well. So the evaluation begins with a designated crisis responder, like we talked about earlier in the training. And so they'll do their evaluation. And if they're go inpatient, then the person can be detained for up to a 72-hour hold, and then the person will be evaluated again. So there can be additional commitments up to 180 days, and they would be ordered by the court. So it can start with a 72-hour hold, it can go to a 14-day inpatient, and then it can go up from there.
And just one quick thing to add here, the 72-hour hold, if they are dangerous to themselves or others due to a mental disorder or substance use disorder. Mm-hmm. And that's language from the RCW. So I just want to throw that out there.
Thank you. So what is the goal while somebody's in the hospital? So stabilization of the person so that they can return to their community as quickly as possible. So not a great place to be in an inpatient hospital, but there is a reason for it. So, and that reason would be stabilization. So what happens when somebody's in the hospital? So we want them back out in the community as quickly as possible. So discharge planning actually begins at the time of admission. So the treatment team will work together to develop a treatment plan. Community liaisons work with finding a placement if needed. So if they don't have a home to go to, a community liaison will help navigate that situation. And they could possibly be given a least restrictive alternative known as an LRA. So what is a felony conversion? So it's commonly referred to as a felony flip. You might hear that term. So if felony charges are dismissed and a civil commitment is pursued, that is what is called a felony flip. A court may dismiss charges without prejudice. Again, that means the charges can be refiled. So if the person is found incompetent to stand trial. So the person is then sent to the state hospital for evaluation.
And a note here is at Western State Hospital, for example, people can be transferred from the forensics ward to the civil ward. So that's,
Thank you. Yeah, at Western State Hospital, they have currently both forensics ward and civil ward. So let's look at some history. So there was the era of institutionalization. So it was widely believed that people with serious mental illness had lacked the capacity to make decisions, and the inpatient was helpful. So many people were involuntarily admitted. And if they were released, they found that they had no property and they had no custody rights. So they lost their property, they might have lost their children. So in response to the abuses of civil commitment, things started to change. This is a good thing. Okay. So in the 1960s, Medicare and Medicaid were established, and new medications were starting to be developed at that time as well. So there was a civil rights movement which began in 1963. Community Mental Health Center Act was signed into law. In 1966, there was a court case called Lake versus Cameron. In 1975, the court decision of O'Connor and Donaldson.
I'll quickly give you a little bit of information on the two court cases. So Lake versus Cameron looked at involuntary hospitalization of psychiatric patients that were not considered to be dangerous to themselves or others. The court ruled that for individuals who meet this criteria, alternative treatment that is less restrictive but still meets the treatment needs of the patient is available. And that makes a ton of sense in today's world. We would think, what? But yeah, so not dangerous to themselves or others, alternative, less restrictive treatment, which is where we are now. So that's great. O'Connor versus Donaldson established that states cannot confine an individual who has been determined not to be dangerous and who can live safely, either independently or with the support of family and friends. To do so violates their constitutional right to liberty under the 14th Amendment. And again, we would look at that now and say, well, of course. But those are two landmark cases that really changed things for us and changed to put us on the trajectory of where we are now. And I think it's really important to go back and look at those and say, yeah, that's where we were and this is where we are now. So
if on a side note, if you want to take some time and look at a book, it's called Suitcases in the Attic, and it's a really good look at what people went through when they were involuntarily committed, in the past. And it's just a great reference to understand where we were and where we are now. Not that it's perfect now, but things have changed.
There's always, more that we can push forward and continue to get better on, but it's really wonderful to go back and look at things the way they were and to where we are now. It's kind of inspiring to see that we've made such great progress.
And there's more to go.
Yeah. Okay, so this is a handout. Again, this is abbreviated somewhat for ease of viewing. This is typically what happens, but not each and every scenario is always captured, and just want to clarify that. It says you can find this on page of your manual. It will be a handout that will be sent to you. Go ahead.
Yeah, we'll send you the handout.
Yeah. So just pull up this handout, but I am going to zoom in and kind of walk through together here. And this is the not guilty by reason of insanity. So I'm going to switch gears on you a little bit. We're talking about civil commitment. Now we're talking about NGRI. And I'm just going to refer to it as NGRI. It's much shorter term. Okay, so here's the process. So it begins with criminal charge. Defense files notice of intent to go forward with NGRI. There's an expert evaluation, and then the court or the jury decides, so it can be a court or a jury, it decides whether the person should be acquitted under NGRI or whether the person presents a safety risk unless kept under further control by the court. So the decision is made. If insanity is not supported, the case proceeds as usual. And again, I just want to clarify that that term is in RCW, it's in law. That's why, we use that term and that language. So then if the individual is determined to be NGRI, there's two pieces here: safety risk or not a safety risk. So, follow along with either side, depending. So if there is a safety risk, then commitment is moved forward with commitment. And a person is examined at least every 6 months. The person or DSHS may petition the court for release or conditional release. And if that happens, then we go here to conditional release. And we also end up at conditional release if the person is not deemed a safety risk. So when we get to conditional release, the person is examined at least every 6 months, same for each one there. Person or DSHS may petition the court for release. The court reviews after 1 year and every 2 years thereafter. And then at the end point here, the person must be released no later than the end of the maximum possible sentence term for any charged offense. So that's good. We can't go over the maximum term. The court may grant earlier release if the person is determined at a hearing by preponderance of the evidence to no longer be dangerous and no longer needing to be under that control. So, thank you, Mo. All right, so that's the process. That's kind of the flow for the NGRI piece. And so what do we mean by NGRI? Again, that's a RCW term. That's the terminology that's in our state law. A defendant is admitting they committed the offense. So they admit that, hey, yeah, I've done that. But they're not able to perceive the nature and quality of the act, and they're not able to tell right from wrong due to a mental illness that satisfies the definition of legal insanity. So yes, I committed the offense, but because of my illness, I cannot understand the nature and quality of the act, and I cannot distinguish right from wrong. So that's the criteria there.
So, and as a definition for what criminally insane means is a criminally insane person means someone who has been acquitted of a crime by reason of insanity and found to be a substantial danger to others or present a likelihood of committing criminal acts jeopardizing public safety or security unless kept under further control by the court or other people or institutions.
Okay, so if the person is determined to have a developmental disability, and again, you can see that's always a consideration, a person may be committed to a specific program focused on habilitation and treatment specific to their needs. So you can remember we talked about the habilitative models in the Western and the Eastern state hospitals, and that habilitative versus rehabilitation. Gaining the skills or regaining and relearning the skills. So if the person does not have a developmental disability, the court will order hospitalization or appropriate alternative treatment. If acquitted by reason of insanity and found not to be a danger to others and not presenting the likelihood of committing criminal acts jeopardizing public safety or security, the court will direct the defendant's conditional release. The limits of NGRI following the acquittal. Treatment can't exceed the maximum possible sentence. We went over that. The court and prosecuting attorneys are notified 6 months prior to the deadline, if not already released. So if that person is not released yet and that maximum possible sentence date is approaching, court and prosecuting attorneys are notified in a timely fashion. The court will direct the defendant's conditional release. If not released within 7 days of maximum sentence, the designated crisis responder will be notified as of why the person will not be released. Then the DCR will determine whether to initiate additional proceedings. So that's in a situation where there might be some extenuating circumstances that need to be looked at. So a little bit about the Ross versus Lashway. This lawsuit has to do with NGRI. So in 2014, people found to be NGRI filed a lawsuit against DSHS. The lawsuit sought to improve services to people found not guilty by reason of insanity and ensure legal process of conditional and unconditional release and discharges were adhered to. So prior to 2010, people were gradually integrated into the community by supervised trips. And
Can I just say a little
Sure.
bit about that
Yeah,
real quick?
go ahead.
So these deliberate trips were a great thing because people can gradually get back into their community and support. So that's prior to 2010, patients received treatment that gradually reintegrated them into the community through supervised trips. These deliberate release planning provided a balance between patient recovery and public safety and resulted in a streamlined release of patients who no longer needed to be at the hospital or stay at the hospital.
All right, so things were chugging along smoothly prior to 2010. And then in 2010, new restrictions were added for individuals found in NGRI. The court order was required to leave the hospital even if it was recommended for treatment and recovery. So things got a little tighter, some additional pieces were added there. So a public safety review panel was created in 2010. Provided an additional layer of review before people found NGRI could leave secure areas of state psychiatric hospitals. Did you want to add something? Okay.
You're good.
Because of the delay these processes caused to treatment and recovery, the plaintiffs brought the lawsuit to ensure timely decision-making while respecting safety. So things slowed down a little bit and the lawsuit was brought. So, not unlike the True Blood lawsuit, it resulted in several steps that the hospital could take. I say not like the True Blood lawsuit in that it brought some good things to the table, resulted in some good outcomes for people. So, there were several steps that the hospital could take to improve treatment and release processes despite new laws. So, so without having to go through the lawmaking process, there are things that the hospital could do. So they ensured individualized treatment plans were in place, increased patients' role in the treatment and discharge planning, always a great thing, include the person, streamline grounds privileges and release processes. So they made those processes easier and more so that people could go back to getting out and about in the community. New requirements for transportation and creation of a more uniform NGR patient level system policy. So those are the changes that kind of were a result of the Ross settlement.
And just to give you some time frame on this, so in 2018, it was anticipated that both state hospitals would have modified their policies to reflect these new laws.
Yep. So it's fairly recent. In August 2019, a U.S. federal court dismissed the Ross versus Lashway case after DSHS demonstrated that it's greatly improved policies and provided patients found not guilty by reason of insanity a better chance of success once they are approved to leave the state psychiatric hospital.
Thank you. So thank you for going through this module with us, Civil Commitment and NGRI. And again, if you would like more information, make sure you take a look at the manual. There's a lot more information in there.
Thank you.
See you in Module 9.